And this is a case between Nokia and HP. This has been a case that has been filed in the US before the District Court for the District of Delaware. And this was a ruling that talked about some of the counterclaims that HP filed in the present proceedings. And what the court did with this decision was to dismiss part of the counterclaims that HP had raised against Nokia's lawsuit, especially a counterclaim which was based on antitrust and competition law. So here, just for our information, it's not about cellular SEPs. We're talking about patents that are relevant for the HEVC standard or the AVC standard. And this is something to keep in mind because we are also not talking about the ETSI IPR policy here. We are talking about a different IPR policy, which is the ITUT common patent policy, which is pretty similar to the ETSI one, but is a bit also has some different structures. So here, what HP did against the claims that Nokia raised was to file a series of different counterclaims, and the court recognized here basically three different categories. One category was the so-called contract-based counterclaims. What is this all about? It's claims that are basically based on a potential breach of obligations, of front obligations under the IPR policy on the side of Nokia. We're going to see in a moment more in detail what this was all about. There was another one, an unenforceability counterclaim, which is linked to the contract-based counterclaims to the extent that basically it was argued here that the patents should not be enforceable because, to a certain extent, Nokia tricked the SDO and managed to get the patent into the standard without being really prepared to offer front licenses of the patent. So this was, let's say, the second line of argument. And there was this antitrust counterclaim, which is based on Section 2 of the Sherman Act. What does this mean? Very generally, that that Nokia had acted in an anti-competitive manner and should therefore be prevented from enforcing the patent. There had been also two other things that HP had raised in the proceedings. It asked for a declaration that it is entitled to front terms, and also asked the court to declare which terms are actually front. And there was also a common law fraud counterclaim, basically arguing here that what Nokia did, especially during the standardization process, was misrepresentation of facts and also false commitments and false comments, and should therefore, at the end of the day, be prevented from enforcing the patents. So what Nokia then asked the court was to dismiss all of these counterclaims, but the court decided to do that only with respect to the antitrust counterclaim. So the contract-based counterclaims were not dismissed. So this means that they are part of the proceedings still. Here, as I mentioned already, what is the background of these claims? For example, that Nokia had made unreasonable royalty demands, that it sought injunctive relief and had unilaterally abandoned the negotiations, and also had breached the duty to negotiate in good faith. So these are basically arguments which are based on the behavior of Nokia in the negotiations towards HP. And here, what the main argument is that by behaving the way it behaved, Nokia was in breach of its obligations, of its contractual obligations arising from the undertaking it made towards ITUT. Now, the court was not convinced by that. It found, on the contrary, that HP had sufficiently pleaded the cases that would allow the court to deal with this counterclaims. There was particularly one topic here which I would like to mention before we go into the over to the antitrust side of things, because I found it interesting. There was a discussion here, and Nokia basically argued that, well, you cannot really allow this contract-based counterclaims because they require that HP has pleaded that the patents are actually standard essential. This is something that goes back to the ITUT front undertaking, which refers basically to standard essential, to actual standard essential patents. So if you would like to construct contractual obligations out of this undertaking, a very important element that you need to plead and show eventually is that the patents are standard essential. So this is something that HP did here. It pleaded that the patents are standard essential. The court also found that it had sufficiently pleaded that the patent claims are essential. But Nokia said here, on the other hand, HP has also pleaded that there is no infringement. So the patents are not infringed, meaning that they are not essential. So how can this be? It seems not to be consistent to argue on the one hand that the patents are essential, and on the other hand argue at the same time that the patents are not infringed and therefore not essential. The court saw that, but it said that at the stage of the proceedings where we are now, HP may be allowed to do that. So it may state as many separate claims or defenses as it has, regardless of consistency. So this was something interesting here, which eventually in other jurisdictions would be seen differently. Because, for example, in Germany, you might indeed have some questions here of whether the actual claim as it has been produced is consistent and it makes sense. But this has been, at least here in the view of the district court, not an issue, at least at this stage. Now then, the court went on to the antitrust, to examine the antitrust counterclaim and whether this counterclaim should be dismissed, and found that it should be dismissed. There were basically three elements that needed to be pleaded here by a claimant who reversed this type of counterclaim. The claimant must plead that the patent owner possesses monopoly power in the relevant market. This is the second element, and has engaged in anti-competitive conduct. The court here saw a problem only with respect to the first two elements, particularly with respect to the second element, the relevant market, because it found that in the present case, HP had managed to adequately plead potentially anti-competitive conduct on the side of Nokia, particularly the allegation that Nokia had made a false promise towards ITUT to license the patents on front terms. But the court was convinced that HP failed to sufficiently plead a relevant market in which Nokia would have a monopoly power, which then would allow the court to have a finding that Nokia eventually acted in an anti-competitive way. What is the relevant market? And the court defined the relevant market here by reference to competing technologies developed prior to the adoption of the standard that perform the function of the technology that was included in the standard. So here the court looked at a rather early stage already in the standardization process and allocated the relevant market during that time, during the time where the standard has not been set yet, where there is still a competition between the different contributions of the different companies, the different technological contributions, And this was considered to be the relevant market here if you want to make an assessment of whether there is a monopoly power and there is potential abuse of this monopoly or the dominant position in the market. The court looked at what HP had pleaded and was a bit puzzled again. What was HP actually arguing here? It was not very clear in the eyes of the court whether HP had argued that there are multiple relevant markets, so one market for the products that are standard compliant, and one market for the technology that has been chosen to be integrated into the standard, or whether HP had pleaded one single relevant market for both products and technology. So the court was not really clear about how HP decided to set up its case here. But the general impression which the court had was that HP was focusing rather on the product market. So basically the market of the downstream market, which includes the products which use the relevant standard here. And the court said this is not correct. Again, the definition was a different one. The court found that HP focused rather on the product and also failed to make an alternative suggestion or to plead an alternative relevant market, which would have been limited to the technology that was competing with Nokia's technology when Nokia's technology was incorporated into the standard. So again, here the court said basically that HP placed the focus on the wrong market, more or less. So it placed the focus on, let's say, a later point in time, a market that is given when you have a standard that has been already set, that has been already frozen, and now you have products implementing the standard, and then you have to take this market, the product market, as a relevant market to look at whether there is a market dominant position or not, or whether it's monopoly power or not, and had really not looked at the stage before, at the situation during the standardization process. And in the eyes of the court, this was a big problem here. That's why this whole base of arguments was not accepted by the court, and it was dismissed exactly because HP had failed here to really determine which is the market it refers to and which market the court should basically take into account when it comes to the determination of whether there's monopoly power or not. So this was an interesting decision, not only because here the antitrust-based claims failed in the US, because we have seen that also in some other decisions in the past that the US courts seem to favor a more, let's say, contractual angle when it comes to SEP disputes. But it is particularly interesting when we compare this with the views taken by other courts around the globe when it comes to more or less the same question. So this question, whether there is a market dominant position, has been raised also in Europe. It has been raised in the UK. It has been raised particularly, of course, in Germany, where most of the defenses against SEP assertion are based on competition law. This goes back, of course, to the decision of the Court of Justice of the EU in Huawei ZTE, which has exactly a competition law base. But here, what is interesting, I think, for us particularly is to look how the courts in the other jurisdictions look at the relevant market, because as we're going to see in a moment, there are some significant difference. So here, when we look at the UK, in the UK, again, maybe the comment in the beginning that antitrust and competition law considerations do not play a central role in the front cases. The UK courts, similarly to the US courts, focus more on the contractual side of things. But in one case, in the Unwired Planet Huawei case, they had also to deal with this type of arguments. And here, the Court of Appeal made clear that for the purpose of assessing dominance, which is the same thing more or less as monopoly power under the Sherman Act in the US. So the relevant markets for assessing dominance in case of each SEP is the market for the licensing of that SEP. So here we are looking really at a different market. It's not the product market. It's not the market of technology which was competing with each other at the moment of adoption into the standard or not, but it is the market for licensing the specific SCP after the standard has been set and after the products are in the downstream market. So different approach here, a different third option to allocate the relevant market for this type of considerations. And in Germany, we have a very similar approach as well. We have the Siswell Higher decision of the Federal Court of Justice, where the court said very similarly to the Court of Appeal in the UK, that when you have a standard essential patent, irrespective of whether this is a patent created by an STO, or whether this is a standard developed by an STO or a de facto standard, the relevant market for the assessment of dominant is the distinct market in which licenses for the patent in question are offered. So this is again looking at the licensing market for the specific SEP, and not, as we have seen here, the district court in Delaware looking at the market at the moment where the technology that is patented was adopted into the standard. This is a different approach, and it's interesting to see that the courts have different views on that, because I mean, one consequence of the fact that the courts in the UK and especially in Germany focus on the licensing market is that, as a rule, you don't really need much consideration and much thought of finding that the patent owner is dominant. Why is that? Because if you look at who can offer licenses for a specific SEP, then it is usually only the patent owner. If you have an exception, and this was something discussed also in German case law, where you have potentially a second option available, a pool option available for the same patent, then again, it's rather difficult not to find that the patent owner is a dominant undertaking, because he would have, in any case, at least 50% of the market, even if there was another option to license the same patent over a pool. So what is the consequence of that is that in Germany particularly, in contrast to the decision from Delaware that we just saw, this question is rather not giving a lot of headaches to the court. They are usually assuming that there is a market dominant position. The analysis then goes a step further to look at whether there has been an abuse of a market dominant position. And there you have all of these discussions around how the patent owner has behaved and whether he has met its obligations under the Huawei ZTE judgment, etc. But this first element, in which HP's claims failed here before the District Court of Delaware, is usually not a very high threshold, especially in German case law. So again, this is something interesting, I think, for us to keep in mind, that here the courts have seemed to determine the relevant market in different ways and looking at different stages of the standardization process. And this can have also different results at the end of the day.